Oyez. Anyone having business before the King's Justice, the Superior Court of Justice, attend now and you shall be heard. Long live the King, the Honorable Justice Hennessy presiding. You may be seated.
Good morning, all.
Morning. When we left off yesterday, we were discussing the 1975 Timber Task Force report, and we left off reminding the court that the data in there still hadn't been subjected to an analysis of, well, what of those expenses are relevant expenses related to relevant revenues. We're going to come back to Hutchings' approach to doing that in a moment, but I wanted to continue on just going through the Timber Task Force report and a couple of other additional items. The court might recall an exchange that I had with Professor Smart in cross-examination relating to indirect benefits that the Crown receives from the forest industry. And if you turn to tab 10 of the compendium handed up a couple days ago and go to pages 55 and 56, that's towards the end of the tab 10, you'll see excerpts of pages 42 and 43 of the Timber Task Force report. And in cross-examination, it transcripts pages 6, 7, 8, 4, and following. This is where I had discussed that matter with Professor Smart. Now, recall, if you will, from the earlier table 18 that the charges assigned to the forest industry in 1974 look to be a total of 31.335 million, and that's from, you can see it at page 52 of the compendium. It's for the 1974 year. And by comparison,
Sorry, page 42 of the compendium?
and on page 52 of the compendium, just flip back there, and on the second last column, you'll see the 73, 74 figure, and in the red box, 31.3 million total assigned to the forest industry.
Okay, got it.
Right. So let's compare that 1974 figure of 31.3 million to what the Crown says, or itself in its own data said it gets from that forest industry. So offset against those expenses are revenues, and if you see on this page, it's total $50 million, a positive amount. And this, of course, is in a period of time when Bodway and Smart say there's money being lost hand over fist.
I'm not sure that I've got the right column, so I'm not in.
Oh, you should be on page 55 of the compendium now. It's up on the screen. Right, so you just keep that 31.3 million from 1974 in mind, and under the heading tax burden, paid.
Okay, but
Yeah, go
I
ahead.
need to get actually the 31.3.
Oh, okay. If you need to get that, go back to page 52 of the compendium. There's the table 18 chart.
I've got it, and I've got the red boxed one.
Yeah, and the second last column,
Got it.
under 73, 74, there's 31.335.
Okay, so
Right.
31.335 is expenses.
Right, that's the expenses which are assigned to the forest industry.
Okay,
And let's compare those expenses to what actually comes in according to the government people. And in the very same report that they report expenses of 31.3, they identify revenues of 50 million. And if you look at page 42 of the document or page 55 of the compendium, you will see an excerpt of Ontario revenue from forest-based industry, 1974, and Crown charges of 29 million, corporate income and capital taxes of 14, retail sales tax and gasoline tax. So they're estimating it's going to be $50 million as against 31 million. Now, just in case,
Just one question.
Yeah.
And Crown charges, those are, for instance, stumpage fees or akin to stumpage fees?
yeah, that's the direct NCRRs as I would think. That's what I think they're talking about, Crown charges. And it might be, you'll see that it says estimated 1974.
Yes.
If you go back to page 52 for a moment,
Yes.
just in case anyone wants to suggest that, well, the amounts you have to compare is not 31.3, but it's 36.2 estimated in the last column. I have to admit, it's a little bit unclear whether they're talking about the actual 74 year or estimated for 74, 75. But my point is the same, whether it's 31 million or 35 million, there's still a net positive amount. And so you might recover only 29 million or generate a loss from natural resources or direct NCRRs, but you're saying this is a good deal for the Crown because look at all the other tax revenues we get from taxes that make up for it. So
Do you say that the reason the Crown says that they were losing money or not making money is because they only counted NCRRs?
Well, yes, in a way, when you say losing money,
Well, they said
Bodway and Smart says that there's money lost. The reason why there's money lost is because they took into account the wrong expenses. So that's the first big problem. But even if they took into account the forest industry expenses, they'd be wrong for the reasons we already articulated about the proper way to you need to still go through Hutchings inquiry as to what relevant expenses are and allocate and attribute expenses. But in a global picture, and we're going to get to a graph in a moment, but in a global picture, the Crown isn't losing money at all. They are making money hand over fist. It's a positive net for the Crown. And remember, this is all proof positive of Professor Stiglitz's smell test. The province isn't losing money on the resource sector. It's making money. But it's making money through a combination of factors. It's making money through direct NCRRs, which they say, yeah, we'll share that. And it's also making money through taxes and gasoline taxes and retail sale taxes, corporate taxes and capital taxes, which push their take to the positive. And remember, Stiglitz's smell test is you just wouldn't keep on losing money year after year for 60 years. At some point, you'd write a check to the Anishinaabe, say, here's like $10 billion, take your land back. We can't make a go of it. We're losing money. But that hasn't happened. And so Stiglitz's smell test is proven true by the 1975 task force report. And lest the court think that it's only $50 million of value to the Crown. The very next page of the compendium is the very next page of the task force report. It says, in addition to this revenue, that's in addition to the 50 million, it should be noted that the employees of the forest industry also contribute to provincial revenue through personal income and other forms of taxes and levies, and various other governments, I guess that's referring to Canada, or municipal governments, also collect property taxes and a variety of wage and salary levies, such as workers' compensation and Canada Pension Plan. So here we have an instance of it's not just 50 million, it's 50 million plus. Now, we don't actually have the details of how much it is, but the point is the government's making money. Yes, it's chosen to incur a loss on Crown resource revenues. But this gets back to direct Crown NCRRs. Remember in the task force reports, it says, well, you know, we got to be mindful of maybe because of the ability to pay of the forest industry and the fact that you know, we want to be mindful of the industry and make sure that they can survive and thrive. We can only charge so much. There is that in the task force report, but the way to accommodate that and be true to your treaty partner is to do what Stiglitz said. And that's, if you recognize that you're giving a subsidy to industry, record it as a subsidy. Record it as a subsidy, but ensure that the fair market value of the thing that you're selling is recorded on the books at fair market value. You're not making the industry pay more. All you're doing is you are saying to your treaty partner in an honorable way, yes, we are charging less than we should be, but we're not going to take that out of your pocket. That's a policy decision that we think is appropriate, and we will pay for it. We, the Crown. And when the question is asked, well, where would we pay for it from? The answer, of course, is at tab 9, page 45 of the compendium. Remember, that's the pie chart of where all the money comes from. Would it be so wrong?
Sorry, page 45.
Page 45, it's up on the computer or the monitor.
Okay.
Yeah. So Stiglitz and Hutchings' model says, if you're going to have a subsidy, whether it's implicit or explicit, rather than compel your treaty partner to unfairly take the burden of that policy choice, pay it through another source, record on your books that you've sold the, or even if you want to go to industry and say, we only charge you $1 for this $10 tree. It's really a $10 tree. We're now going to start charging you $10 a tree, but we're going to give you a $9 subsidy.
Is it a $10 tree because that's what the expenses make it?
No,
Or that's the fair market value?
it's a $10 tree because that is the resource rent value of the tree. And that is an objective, verifiable fact, which Stiglitz and Hutchings did. Now, admittedly, when I say an objective, verifiable fact, it's an estimate. The best they could do is estimate, but it is conceptually something that is known and knowable if you have all the data. And when we talk about this idea of making money through other sources, 50 million plus workers' comp, plus Canada Pension, plus personal taxes and other levies, I want to jump to compendium tab 11, page 77 of the compendium. Because you might remember that Mr. Hutchings gave what I thought was a really informative graphic of how that all sort of plays out in the real world. And what he did is he produced a graphic, and he shows on the very bottom, the lowest line is Bodway and Smart forestry revenues included. The red line is their expenses, and obviously expenses in each year exceed revenues. But then you compare it against all the benefits and all the wealth that's derived and taken by the government and by industry out of the forests that were once belonging to the Anishinaabe. And you see the stark difference in wealth derived and revenues afforded to the Anishinaabe under Canada's, Ontario's scheme. Now, we would add, of course, that even Stiglitz and Hutchings' model has the Anishinaabe sharing only a minuscule portion of what is depicted on paragraph, on page 77 of this chart.
Sorry, they show only a minuscule portion.
Yeah, in their report, even Stiglitz and Hutchings, if you were to plot, and it's not plotted on this particular graph, but if you were to plot it, their net Crown resource revenues, both direct and indirect, are only a minuscule portion of the nominal GDP from forest-related industries tracked by Ontario during the period. And you can gather that from the data in his work papers. It's not depicted here.
Is it by chance, you said from the nominal GDP?
That's what figure 2 is that we're looking at. Yes, go ahead. Question.
So is the nominal GDP the total of those shades of green above the red lines?
Yes. What it's doing, and you see the various the various areas of who's making the money. I'll put it that way. The light green is the paper manufacturing is making the money. The darker green is wood products manufacturing is making the money. And the darker bluish green is gross domestic product supporting activities for forestry. Then there's the darker blue, I would call it, gross domestic product, forestry and logging.
Right.
Right. So these are all, it's a good graphic to say the forests of the Anishinaabe are now benefiting a lot of people, but they're not benefiting the Anishinaabe. And to be more accurate, it's not the forests, it's the forests that have been cut down.
It's the economic activity in the forest.
Yes,
The
yes.
extraction of the resource.
It's the extraction of the resource, that's right. So, having identified the problems with the 1975 task force report and identifying the need to figure out what expenses properly match relevant revenues, I go back to tab 11, which is Hutchings' inquiry. How do you figure out what expenses matter? And this is discussed at 5.2 of our main argument, pages 87 to 93. It is discussed in detail in Hutchings and Hutchings' report. I don't have the pages 107 and following in his opening report, but I've included in the compendium just the graphics he had in his demonstratives, which were Exhibit 11 at phase or stage 3. And I thought that I would just remind the court, I don't know if I need to go through it in detail, but I would remind the court of his approach.
Okay, just before we get there.
Yeah.
A question on the Timber Task Force report.
Yeah.
Do I recall that this report was written by industry?
I think there was some suggestion that that industry was consulted. And Professor Smart, and I'm just going from memory here, but I'm pretty sure I'm correct about this. I believe it was Professor Smart who said, you know, you have to take this with a grain of salt because industry may have influenced the numbers here. I think that's the tenor of his evidence, and I wouldn't mind if Ontario thinks I'm wrong about that summary, they could just stand up and right now and just tell me.
But it was produced by the provincial government, but in consultation with the industry.
Right, that's correct. In consultation with the industry and not in consultation with any Aboriginal people, I might add. As I say, if my recollection of Professor Smart's evidence as I stand here today is in any way misleading the court, if anyone knows that it's wrong, please stand up and say so.
I want to go back to that page. The page where it showed the revenues coming up to 50. What is that?
Where it shows the revenue coming out to 50, did you say?
Right.
That would be, that was at tab 10, compendium page 55 and 50, 55 and 56. Is that what you were looking for, the
Yes,
50 million plus?
Yes, thank you.
Okay. So, having dealt with those questions from the bench, I was going to.
No, I have a question.
Oh, yes, yes.
Thanks. So if I understand this page correctly, this is would be a Crown demonstration of their acceptance of the Stiglitz model of what do we get from the revenue, or what do we get from the natural resources?
Yes, I don't know that they deny that they get that from the natural resources at all.
No, but this is a demonstration of that.
This is a demonstration of it, and it's also a demonstration of a smell test as to why they would do it.
I'm going back to tough questions for you, possibly.
Yeah.
When we look to the intention of the parties,
yeah,
at the time they made the agreement and parties were making a promise, and neither side contemplated taxes of any sort, and neither side or neither party possibly could have conceived of the size of the industry and therefore the complexity of it and therefore the taxation of it. How do you square the words production from the territory with the inclusion of those things out of the conception of the parties at the time?
I want to start with your proposition that it was out of their conception.
Okay.
And I don't accept that. I think it's wrong, because what the parties did conceive of is exactly what Vidal and Anderson said: any new source of wealth. The idea and the shared intention of the parties was to do just that. share any new source of wealth, which they identified as productions from the treaty territory. And so what they were thinking of is, if the Crown makes money, we make money. We will share in this land. We will share in the waters. We will share in the, if there's a road running through that they would toll, we would share that. You remember there was evidence in stage one about the Anishinaabe charging tolls, about using the land. So whether it was a mineral or whether it was a right over the land or administration and control over the land, whatever would come into the government's coffers, that is what is to be shared. It got expressed as productions of the treaty territory, and most mindful in the people's minds in 1846 to 1849 was mineral wealth. That's true. But the Anishinaabe did not conceive, remember the evidence, they did not conceive of their land as restricted to minerals. They conceived of their land as their land to which the Creator would provide them with the means to achieve Bemadzwin. In the Anishinaabe perspective, the land provided for them in their generations. I believe our lay witnesses testified to that to some extent. So your initial premise that they only agreed to share a certain portion and didn't contemplate taxes, I think it's a little bit unfair to the history. To what we can admit is that taxes of the kind we're talking about here, income taxes, they were factually unknown, but there were customs and excise taxes, right? And you might recall in the evidence that initially Canada wanted to include in those taxes. But then after Ontario presented their numbers that in the, I think it was the 1870s or 1890s, if the court needs me to track it down, I could, but I recall it. It disappears from the equation, and ends up being left on the cutting room floor, so to speak, and this is kind of reflecting Gwyn Jones's testimony from phase one about, and the court's finding, I believe, in phase one, that by the time Ontario and Canada do their agreement, both of them have an interest financially in keeping the amount of net revenues down. So income taxes, I think they came in as a temporary income war tax act in 1916. Still living with that temporary income war tax act. But the real thrust of the intention of the parties just harkens back to Vidal and Anderson, to share in any new source of wealth.
And therefore, do you say that, or I can ask this of the Crowns, that what we see on page 55 of tab 10 is an acknowledgement that taxes are a source of wealth coming from the territory?
Well,
Is that, I'm just trying to figure out how to describe what we see here.
Yeah, it's an acknowledgement that the taxes, it's an acknowledgement that the natural resource exploitation does not just result in direct revenues through stumpage fees. It also results in other forms of benefits the Crown receives. by way of taxes and other benefits as well. So for example, you can spend money on a railroad for the purpose of not getting money, but for building a nation, right? And that might be an important factor for a government. But that's not, the question is, should the Anishinaabe be expected to pay for that? And I think Mr. Hutchings was saying, well, if you want to include in all expenses, you have to include in all revenues. And we don't take that, please understand, we are taking the view that in terms of past compensation, the focus is not on the income taxes. We're saying it should be, you take the direct and NCRRs as calculated by Mr. Hutchings. And I'm going to just use the 60-40 number, bring forward around 56 billion to 2020. You add to that the portion of the resource rents captured indirectly through taxes. That brings it up to 77 billion. And then you ask yourself the question, how does rents factor in? Where is the lost opportunity between 77 billion and 126 billion? Now, according to Professor Bodway, we should be asking the question above that, the green bar, the optimal, but we're not, we've self-limited in a conservative way, asking the question, how much of the difference between 77 billion and 126 billion is appropriately could have and should have been captured such that it's part of our lost opportunity to engage in a process. So that's how we confine our case. We are not coming out and saying the Crown must account to us for corporate taxes it receives, because the Crown will say, well, wait a second, a lot of the corporate taxes we receive don't have to do with natural resources, but it's a tax on capital. It's a tax on investments people make. And I think that would be fair. Now, in a future engagement process, I can tell you, I would expect everything's on the table and we would talk and say, well, you know, maybe given the way the industry has changed and the lack of reliance on customs duties nowadays, and given the way that the revenue streams have changed, it might be appropriate to revisit and renew the sharing arrangement such that we're not just talking about wealth from natural resources, but we have, the Anishinaabe would say, 3 equal governments that need to discuss how to fund their jurisdictions. Now, that's for discussion. I am not suggesting the court order that anything of that nature. I am suggesting to the court that if we ever get to the engagement table, I can imagine everything will be on the table.
I thought you said in that last answer, we're not looking for all those corporate taxes. What is the 30%? I thought that the 30% is a portion of the indirectly collected, a portion.
Right.
The indirectly collected
Sorry,
revenue.
we're not looking for a portion of the income taxes that are unrelated to the natural resources, right? Now, could we make a case for including them in? Yes, I think we could, but we didn't. We didn't because of how the wording of the treaty, the spirit of the treaty, if you wanted to expand it, might say any and all wealth, right? But the wording of the treaty and the productions in the history of the treaty tied to productions from resources has confined us, again, conservatively and realistically, to an approach that we think is sustainable by the court and certainly does not overreach matters. And I guess I would ask an interesting way to ask the question is, suppose the Treaty of 1850 were being made today with partners of equal bargaining strength, and everyone knew that there were income taxes were derived from the wealth of the treaty territory. You might expect the Anishinaabe to say, well, you know, you're actually making most of your money through taxation, not through resource production anymore. And all of these are still coming from the territory. So we want a slice of that pie too. So what might happen now is different, I think we have to recognize, than what happened in 1850. And that's what renewal is about.
Thank you.
So before this series of questions, I was going to, I actually mooted the question. That it took us back, I think, to how did Mr. Hutchings identify relevant expenses that supported relevant revenues? And I had indicated that he talks about this in his opening report at paragraphs 107 and forward. I said that we talk about it in at Article 5.2 of our main argument, pages 87 to 93. And I was wondering just how much detail I needed to go into in terms of helping the court, if the court had any questions about Mr. Hutchings' methodology of identifying relevant revenues, relevant expenses. And I thought I would just highlight it rather than go through every slide in detail.
No need to go through every slide.
Okay, so I'm not going to go through every slide. I thought Mr. Hutchings did a good job of doing it in direct, but just to remind the court, at tab 11, slide 57, he starts off by asking the question, if you take a look at all the Crown resource-based expenses and divide them up into fully relevant, which are fully included, not relevant are fully excluded, partially relevant would be partially included. And then if you go over to page 60 of the compendium, he makes the important point that expenses must be related to resource revenues, not resource rents, in effect. So step 1, identify the relevant resources. Step 2, identify relevant Crown revenues from those resources. And 3, identify relevant expenses related to those revenues. And the court may recall that as an example, Mr. Hutchings used, well, why would you include in reforestation expenses that may have been incurred province-wide, but when you actually look at where they were incurred, it was in Southern Ontario, unrelated to the treaty territory. So that's not related to a relevant revenue, even though the idea of reforestation is something that would apply to the territory generally. At page 66 of the compendium, one of the litmus tests that Mr. Hutchings uses that Ontario takes issue with is the idea that what should be counted is an expense that was incurred in the expectation that it was a worthwhile expense and would lead to something. So the general principle, he says, would someone reasonably expect the incremental increase in included relevant revenues to be greater than the expected portion of the expense attributable to the relevant revenues? And contrary to Beaudoin and Smart, he does say, look, there can be negative or zero amounts. There can be. But the important question is, if you're looking for expenses that are related to supporting, regulating, or collecting a revenue, there has to be, if you're incurring that expense, you have to ask yourself, as someone who's spending the money, am I doing this to try and actually get money back? Is it an investment in this resource that is going to see any net benefit? Now, Mr. Hutchings does not say it has to be a benefit incurred in the current year. He doesn't say that. But he does ask the question, is there an expectation that incurring this expense is going to lead to any revenues? And so when you get to things like railroad subsidies, they weren't incurred with any thought in mind that there was going to be revenues generated from mines or minerals. They were incurred for wholly other purposes, legitimate purposes, no doubt, but not purposes for which they were generated for the purpose of supporting a relevant revenue.
And is the fact that
Supporting a relevant revenue, yes. Supporting, regulating, or collecting, yeah.
is the fact that railways may have had an impact on resource revenues somehow considered? So it wasn't the purpose, the original purpose, you say was not to support resource revenues?
Yeah, no, the answer is no. And the reason why the answer is no is because you could say that of virtually every single expense anyone could incur, because it's not, you have to draw a line somewhere, and to say that an expense somewhere down the road has an incidental effect that someone took advantage of is not what Mr. Hutchings did. It's what I think Beaudoin and Smart did, is to say any expense that by happenstance had a positive effect, we take into account. But they don't take into account the other side of the ledger of expenses that were incurred and are chargeable that give rise to other benefits. So for example, there are expenses that Mr. Hutchings takes into account that, well, had an incidental effect on creating more population and creating more income taxes, but we don't get a share of that. I mean, to the extent that it's taxes from the resources, yes, but to the extent that it's taxes generally, no, we're not capturing that. So it's not enough in Hutchings' analysis, and I am urging the court to accept his methodology on this and to reject Beaudoin and Smart's opinion on it. It's not enough that there's an incidental possible positive effect.
Or the expense to be
For the expense to be deducted. Someone has to advert to, I'm spending this money to try and support the industry. And by support, I mean support, collect, regulate the industry. So that brings me then to the logging tax, and a side note on the public accounts. New topic. Now, the court will remember that and just for timing, I guess I would go to 11:15 and then we break if that's okay.
Thank
Yeah.
you.
And Ms. Lewis will, I'm sure, remind me when I forget my timing. Logging tax and a side note on public accounts. So logging tax figures into the calculations here for the period 1951 to 1980. Mr. Hutchings says that logging tax, like mining profits tax, is a revenue stream. And that's Hutchings' reply report exhibit 10, pages 25 to 26, paragraphs 48 to 50. Professor Mintz, called by Canada, conceded on cross-examination that logging tax is a revenue stream. And that's at cross-examination transcripts, page 2945, lines 2 to 8. We also know that Professor Bodway said nothing on the stand about logging tax. The issue, the court will recall, is whether a logging tax ceased to be a provincial revenue stream for the purposes of annuity augmentation when the federal and provincial governments legislated income tax credits that companies could take advantage of to offset industry's cost of the tax by reducing their income tax liability. So I don't think Mr. Hutchings did so, but it reminds me of a little bit of a moving around of a shell game. You can, and this, it's all of a sudden something that is a natural resource revenue disappears because of a policy choice to give a subsidy. Now, Professor Smart, at his slide 40 in his demonstratives, made it appear that at 60/40 bring forward rates, the money at stake was $7.4 billion, and at bond rates, $1.6 billion. So a big chunk. But the court will remember that Professor Smart presented his data on a province-wide basis. So the effect of the final numbers, well, that appears quite dramatic, is actually not that dramatic, but I thought logging tax was a good example for what it teaches us, or what the lessons we learn about how you can, I don't want to say manipulate, that might be too strong of a word, about how the effect of policy choices on giving subsidies can cause an appearance that the wealth that you're getting from the treaty territories disappears, when in fact the wealth is still there. And what the example of logging tax does is demonstrate to us that even though there's federal and provincial tax credits, there is still the understanding of government that they are extracting a portion of the resource rents. We're going to get to that momentarily. So while the real numbers are not as high as slide 40 would have of Mr. Smart's demonstrative, Professor Smart's demonstratives would have you believe, they are not insignificant. We've gone through Hutchings' work papers, and at 60/40, the net amount over 173 years is 799 million and 178 million at bond rates. So not an insignificant amount at 60/40, 799 million, but certainly not 7.4 billion. So now that we've identified the size of the issue and have observed that Hutchings and Mintz agree that it is a shareable revenue stream, what then does the evidence tell us? First, I want to the court to recall that during the cross-examination, Professor Smart admitted that while logging tax was included in the public accounts as a revenue stream, he, Professor Smart, chose to ignore that revenue stream. Now, I pause here for a moment because you might remember that Professor Smart said the public accounts are sacrosanct, and that one should not waver from them. But at least in this instance, when it suited his conclusions, the public accounts didn't govern, and one need not simply obey the public accounts. Now, this admission, if you will, that the public accounts don't tell the full story and cannot be relied upon to tell us what revenues are in and out, reaffirms Stiglitz and Hutchings' views and tells the court that the court should not treat the public accounts as determinative of issues. So we now have to examine to see who's right about this. Is the logging tax a proper revenue stream as Stiglitz and Hutchings and Mintz say, or is it not, as Professor Smart says? Professor Smart was confronted by me of the history and the explanations for the logging tax in the 1967 Ontario Commission on Taxation, Volume 3. And you'll find this exchange, and I'm not going to ask the court to turn it up, but if the court wants to go back there, it's at, the exchange was at transcript page 6919 and following. And the Ontario Committee on Taxation report is Trial Exhibit Phase 3, tab 1-5293. And I've got pages 365 to 367, or electronic pages 383, 385 noted. And I've included some of those pages in my compendium at tab 12 that I want to discuss. Recall that Professor Smart disagreed with me that the meaning and intent of the authors of the 1967 government report on taxation was that logging tax helps the province recover more of the economic rent from its system of crown charges. Respectfully, although he didn't agree with me, I believe the document supports the proposition. I want to take the court to what the Ontario Committee on Taxation says. And this is at page 82 of the compendium, tab 12, at the bottom of the page, the logging tax. I'll wait for the court to get there and then I'll continue.
Go ahead. 82 of the compendium.
Page 82 of the compendium.
12, I find it.
Right, tab 12.
Thank you.
So what you'll see that I've yellow, I guess parts of it is yellow highlighted. I'm going to read the yellow highlighted parts, paragraph 40. The logging tax was introduced in Ontario in 1950 as a marginal revenue measure. Going to the yellow, continue on with the yellow highlight. In 1961, over to page 83 of the compendium, the tax ceased to have an impact on logging companies in the wake of a federal provincial arrangement that permitted these companies a full credit against their federal and provincial corporate income taxes. Over down on page 40, paragraph 44 on the bottom of this page. But the existing tax credit arrangement raises in our minds considerable doubt about the advisability of retaining the logging tax. And then at paragraph 46 on the next page is the important observation. In principle, additional provincial revenue from logging through such devices as the logging tax and its accompanying credit arrangement is justified only if the province is in fact deriving less than its fair economic rent from its system of crown charges. And then they continue on in the yellow highlight, the present credit system, which absorbs the entire burden of the logging tax on the operator while producing a transfer of funds from the federal provincial government, is evidently based on this premise. And then at the very bottom, not yellow highlighted, the committee makes a recommendation that in the negotiation of general federal provincial fiscal arrangements, Ontario offered to repeal the logging tax in return for an additional share of income taxes imposed upon taxpayers engaged in logging that approximate the present net return to Ontario from the existing logging tax arrangement. And so what the authors are saying is, look at the purpose of the logging tax is to capture more of the economic rent. And rather than go through this artifice of collecting and then getting refunds, just collecting and then getting tax credits and transfer of funds from the federal to provincial government, let's just get the money directly from through federal provincial fiscal agreements. We don't need to actually identify it and consider it recorded on the books, if you will, as money coming from the natural resources. It can just be part of a federal provincial fiscal arrangement. So what this document helps explain, this Committee on Taxation report from 1967, is that the logging tax was a means by which the province captures a greater share of the resource rents, and that the subsequent policy decisions of the Crowns to permit tax credits is a policy choice, does not render the logging tax not a revenue source. The logging tax, like the mining profits tax, is a revenue stream closely related to the use of or licensing of lands and waters, and should be included, just as Mr. Hutchings, Mr. Ariden opine. Sorry, who did I say? I said Mr. Ariden. I should have said Mr. Professor Mintz in that last comment. Thank you, Council. We get now to post 1945 expenses. The court may recall that, just to set this up, at our argument, we discussed this in our main argument, paragraphs 438 to 450. And we deal with it extensively in our reply argument as well at paragraphs 61 to 111. Hutchings' reply report discusses it a fair bit at Exhibit 10, paragraphs 26 and following. And Hutchings' main report discusses this issue at paragraphs 121 to 126. Now, in our main argument at paragraph 438, we pointed out that Hutchings explained that the public accounts lacked sufficient granularity and detail to make reliance on them unreliable for his calculations of NCRRs. Now, it's important that the court appreciate that the position the plaintiffs are taking and that Mr. Hutchings taking is when we try using our methodology of identifying relevant expenses, we could not obtain sufficient granularity from the province-wide data on which to identify what expenses counted or properly counted. At paragraph 439 of our main argument, we then brought to the court's attention the fact that in cross-examination, Professor Smart all but conceded Hutchings' opinion. Now, I want to keep in mind that the opinion of Hutchings, I want to emphasize this, is that the public accounts were unreliable for the purpose of Hutchings' calculations using Hutchings' methodology, where the expenses that count are the expenses that support collecting, regulating, supporting relevant revenues, not any resource rents generally. I am not going to take you to the transcript itself. It's found at pages 7021 to 7022, but we do stand by our argument at paragraph 439 that Professor Smart did concede Hutchings' point that the use of the public accounts would not provide sufficient granularity to enable an economist to identify relevant expenses using Mr. Hutchings' approach to expenses. Now, the reason why I've set that up is because of the following. At paragraph 112 of their reply, Ontario Council suggests that I was mischaracterizing the evidence because they say Professor Smart's admission that the public accounts would not provide a sufficient level of granularity was based on using Hutchings' methodology for calculating NCRRs. I want to stop there. Respectfully, that was the whole point of the admission. Not that it's not that there wasn't sufficient granularity for some other exercise, but there wasn't sufficient granularity using Hutchings' methodology. The whole point of the admission secured from Professor Smart was that if the court accepts that the relevant expenses are those that support relevant revenues, as opposed to expenses that support resource rents generally, regardless of who collects those resource rents, then even their own witness, Professor Smart, admits that the public accounts are insufficient. At paragraph 108, was there any questions on that exchange? At paragraph 108 of their reply, Ontario argues that it was wrong for the plaintiffs to suggest that Bodway and Smart treated the public accounts as sacrosanct when even they, we argued, knew the accounts had to be wrong. Now, I don't think that was unfair at all or wrong for us, because the use of the words sacrosanct was their words, not mine. On May 17th, 2023, transcript page 5970, the witness, I believe it's Professor Smart, described the public accounts as sacrosanct, to be treated as one would treat a Bible. And if you look, I've got a note here, one could look at slide 38 of 161 of Exhibit 70. I don't know if we've got that in the compendium, Ms. Lewis. I don't think so. Um, My point is, and the point I was trying to make in my argument is, if someone treats data as a Bible to be abided by, as sacrosanct, one doesn't waver from it, but one obeys it completely. That is the definition of slavishly following. And I don't believe I was unfairly characterizing their views on the public accounts in this regard. Secondly, at paragraph 109, Ontario argues we allege that Bodway and Smart admitted that the public accounts had to be wrong. Well, no, we did not say that they admitted the public accounts had to be wrong. Didn't say they admitted it, admitted that the public accounts had to be wrong. If you look at what we said at paragraph 502 in our main argument, we actually provide a list of errors we allege they made under the heading errors made that Bodway and Smart did not agree with. So we have a list of errors we say they made. We don't,
POA.
sorry?
A list of errors the POA made,
Bodway and Smart.
Ordway and Smart made.
Yeah, and the accusation against me is that I argued that they admitted this. I didn't argue they admitted it. What I expressly said is they didn't admit it, but in fact, if you actually take a look at it, I argue they are wrong. That's what I said at paragraph 502, but Ontario ignores that. And one of the errors I said they had, that they made, but that they didn't admit to, was treating the public accounts as sacrosanct. And we argue, we don't say that they admitted, but we argue that even Bodway and Smart had to have known that the public accounts were wrong. And this is a shorthand reference to the point Mr. Hutchings made about the expenses related to hydro revenues. Bodway and Smart say the public accounts say zero. But common sense tells us that there had to have been at least some expenses to collecting, regulating, and supporting hydro revenues. Yet the position of Bodway and Smart is there were no expenses in the public accounts, so we can ignore it.
We can ignore.
We can ignore the reality that there were some expenses. You might remember Ontario's other witness, Mr. Hamal, was quite certain that there were hydro expenses, contrary to Bodway and Smart. And he agreed after a long, lengthy discussion that the 2% expense ratio was a fair and reasonable one.
I thought this point was that the error you pointed out of Bodway and Smart was that they didn't hold to one of their foundational assertions, which was POA was sacrosanct.
Right.
But in fact, this is an example of them following the POA.
When it suits their purposes. That was my point, right? So sometimes they do, sometimes they don't, when it suits their theory. But in evidence, they did say it's sacrosanct. It's the Bible. You can't vary from it. So we stand by our common sense assertions supported by Ontario's own expert, Mr. Hamal, and of course by Mr. Hutchings as well, that even the public accounts don't record expenses related, even though public accounts don't record expenses related to hydro, there are probably some expenses that the Crown did incur, and Mr. Hutchings fairly sought to include them, even though they weren't in the public accounts. Now would be a very good time for a break.
Thank you. We'll take the break, 15 minutes.
Yes.
Court is stood down for 15 minutes. Court is resumed. Please be seated.
Continuing on now with the post 1945 expenses. In our main submissions at pages 94 to 96 and paragraphs 438 to 450, we introduced the explanation as to why Mr. Hutchins was of the view that he could not rely on the public accounts. And in our reply arguments at pages 13 to 22 and paragraphs 61 to 111, we went into significant detail explaining the reasons for the lack of usefulness of the public accounts. Now, Ontario argues at paragraph 109 of their reply that Mr. Hutchins admitted that the public account data was reliable. I think this is a bit unfair in describing Mr. Hutchins' evidence. What he testified to was that the public accounts are reliable for the purposes for which they are prepared, which is a different thing than just stopping at the word they're reliable. And this is a trial transcript, page 1514, lines 21 to 22. Yes, trial transcript 1514, lines 21 to 22. And when Mr. Hutchins was further questioned by Ontario's counsel at page 1515, lines 12 to 16, counsel for Ontario, I thought at the time, fairly clarified that what Mr. Hutchins was agreeing to was simply that the numbers were recorded in the books accurately. And I want to read from the actual exchange at page 1515, lines 12 to 15. Well, I guess I'll start earlier at line 4 on page 1515. The court says, but maybe Mr. Hutchins did. You said I have no basis to dispute. I think they're reliable for something. And then you had a question, the witness. I said, I think they're reliable for purposes for which they are prepared. Ontario counsel at line 12, question, right. And what I'm trying to get to is that you're not disputing whether this 6 should have been an 8 or the accuracy in terms of the data. Answer, that's correct. So the point is that Mr. Hutchins wasn't saying that the public accounts are reliable for the purposes of employing his methodology to calculate net Crown resource revenues or rents after 1945. To suggest otherwise, as I think the impression Ontario means to leave, is not fair to the witness. Finally, in reply at paragraph 109, footnote 224, Ontario argues that we, the plaintiffs, at paragraph 427 of our main argument, have admitted as to the reliability of the public accounts. Now, I've looked at our paragraph 427. I could find no such reference to the public accounts as well, although as an officer of the court, I can tell you that the plaintiffs do say that for the purposes for which they were prepared, the public accounts are accurate. We don't take issue with that. So, but we don't say that they're reliable for the purposes of calculating NCRRs. I wanted to highlight some of the reasons and back and forth about why the public accounts post 1945 are not reliable for the purposes for which Mr. Hutchings and Professor Stiglitz needed it. And here I'm focusing on parts of, not all of, but parts of our reply argument that on this point that starts at paragraphs 61 at page 13 of our reply argument. Ontario, and I'm reading from paragraph 64 of our argument, Ontario, in a lengthy exchange with Hutch.
Argument or your reply argument?
Reply argument.
Thank you.
Paragraph 64 of a reply argument. Ontario, in a lengthy exchange with Mr. Hutchings during cross-examination, unsuccessfully sought to challenge Mr. Hutchings' post-1945 expense ratio of 31.9%. And that cross-examination is found at pages 1609 to 1634. Now, no mention of this part of the transcript is found in Ontario's argument. And I would suggest the reason why you don't find it in Ontario's argument in their summary of the evidence is because it didn't support their case. But in their arguments, Ontario, instead of relying on the evidence from that took place in the trial, ends up relying on arguments not based on the evidence, and we're going to get into that right now. So at paragraph 66, we say Ontario's counsel sought to demonstrate by using charts made up by one of Ontario's legal team that the post-1945 expense ratio used by Hutchings was wrong. And the court might recall that Ontario put forward a base year for comparison. And if the court would please turn up tab 13, you'll find all those expense ratios. Tab 13 of the compendium.
Remind me the genesis of this.
The genesis of this was, and I actually wasn't sure myself that during the trial I stood up, and it was created from work papers by one of Ontario's counsel. There is no, I have no reason to doubt that the data itself is a fair summary of Mr. Hutchings' work papers, that it is transcribed properly. What we do say is that, and we will argue, and Mr. Hutchings did explain, is that the use of the data that Ontario, the way in which Ontario tried to use that data was not fair or proper. So you might recall that Ontario put forward a base year for comparison of 1935 to try and show extreme variation in the base year. But Mr. Hutchings explained that 1935 was only a partial fiscal year and was not at all representative. I think the court might remember that. And I would add to that, of course, 1935 was a depression year, and you've got to be very careful of just making generalizations over 173 years based on the depth of the depression. Now, Hutchings also explained during cross-examination why Ontario's numbers were unreliable and how Ontario's numbers were not demonstrating any valid critique of his 31.9%. He made the point that even during the 1945 period, revenues and overhead expenses were moving differently. And that's cross-examination page 1632 at line 8. Mr. Hutchings also explained in cross-examination that there was no reason for the head office expense to have gotten any more complicated after 1945. That's at page 1632, line 11. Importantly, Mr. Hutchings explained that in the 10 years prior to 1945, revenues tripled, but overhead expenses didn't move. Cross-examination of Hutchins, 1632, lines 15 to 17. Mr. Hutchins explained that revenues before and after 1945 increased. Hutchins cross-examination 16 page 1632, line 8 and following. And what Mr. Hutchins explained is that when there is no discernible change in a government program and expenses have not been rising in an unusual way in which those programs are delivered, when the method of accounting changes, as it did in the years leading up to 1945, such that the reader is left with no ability to fairly identify the properly attributable costs, one should not immediately assume that all of a sudden costs are rising exponentially for no reason. It might just be that it's a problem in accounting, not a genuine increase in costs. And at this point, I would want the court to keep in mind that it should not be forgotten that the consequences of the unavailability of reliable data from the treaty territories ought fairly to be borne by the party who had the treaty obligation to maintain that data but did not. It would be contrary to the principles of law to fault the victim for the lack of information that the wrongdoer was legally bound to maintain but did not. We've already seen this principle in law, and I'm not going to go to the case law about it.
Let me just catch up for one moment, please.
Yeah. And if I'm going too fast, just please tell me. And I apologize to the court reporter because I'm pretty certain I've been going a little bit too fast.
So it occurred to me as as I was listening to you on post 1945 expenses, that you were coming to this point that the consequences of either unavailable or unreliable data should be borne by the party responsible to maintain the data.
Yes.
So I just wanted to go to, what was the point? So when you discussed the issue with Professor Smart about following slavishly the POA or following when it suited him, do you say that in your words, I suppose, regrettable difference in how he regarded that data is a consequence of the Crown not keeping the data in a way that would have been necessary for the implementation of the treaty?
Well, that's kind of two questions I think balled up into one. First of all, remember prior to 1945, and I think Mr. Hutchins gave examples in the early years, I think he may have even used 1923 to explain. In the earlier years, there was such granularity, even in the public accounts, that he could make something of it to provide evidence that was reasonable and appropriate for an economist of his experience and understanding to appreciate how to apportion and attribute expenses that support relevant revenues. Now, had that same granularity been in the public accounts, he could have continued that exercise. But the manner in which expenses were aggregated in the years leading up to 1945, and to be fair, I think his evidence, he chose 1945 as a cutoff year, but he testified he could have done it a couple of years earlier.
He said in the years leading up to 1945, there were changes.
Yeah. And so the aggregation of these province-wide numbers is what prevented him from what changed between, the period up to around 1945 and after 1945. And the obligation, quite frankly, is not simply to provide province-wide disaggregated numbers from which the plaintiffs could spend, God knows, I don't even want to talk about the amount of money it might cost to hire economists to go through each year. The obligation is actually to maintain the data on a treaty-wide basis, not on a province-wide basis, disaggregated. It was a difficult enough task for Mr. Hutchings to actually go through the pre-1945 data to properly capture those expenses that are relevant to related to relevant revenues. It would have been a much easier exercise had someone had taken on the responsibility to do that which the treaty required, which is to keep track of revenues and expenses on a treaty-wide basis.
Treaty territory
Basis, yes. Have I answered your question?
Yes, I thought that was the question I was asking, that if the consequences of the unavailable or unreliable data, i.e. not collected on a treaty territory-wide basis,
Yes.
should be borne, it's just your point, should be borne by the party responsible to maintain the data.
That's right. But even if you ignore that and you just ask the question, is it good enough? Could a reasonable economist decipher the public accounts post 1945 to ascertain what expenses might reasonably be attributable to relevant revenues? The answer is no. The answer was, with much difficulty prior to the period 1943 or so, yes, with difficulty, but after 1945 and forward, no. So faced with the lack of reliable data that he could use to complete his task, he did what a reasonable economist should do, and he found another way to estimate the relevant expenses to be set off against relevant revenues. Ontario's council sought to attack the use of 31.9% average expense ratio on the theory that there were employee numbers available from departmental records as opposed to the public accounts. And they suggested that this would permit a proxy model to be developed to identify relevant expenses. And this exchange was at page 1676 to 1679. But the court should remember that Mr. Hutchings did not agree that developing a proxy model as suggested by Ontario would be a meaningful one. That's at page 1678 to 1679. In fact, when he was pressed on the issue, Mr. Hutchings explained that using a head count does not account for differences in salaries and benefits and the like, and Hutchings ended up disagreeing that such a proxy would be helpful because no one would know what functions are included, not included, or partially included, so that anyone looking at the data, to use Mr. Hutchings' words, would be no further ahead. And that's at page 1682, line 13. Hutchings concluded at cross-examination 1684 that to allocate expenses using a head count would not be accurate. Now, in light of that exchange in the evidence, it was surprising to read Ontario's argument at paragraph 20 that Mr. Hutchings admitted that a proxy for expenses could be constructed to allocate head office expenses. Mr. Hutchings said no such thing. Now, notwithstanding Hutchings' rejection of Ontario's theory, Ontario now asks the court to give weight to the possibility that a proxy model based on head counts could have been constructed to identify relevant expenses after 1945. Respectfully, there is no basis for what is just supposition on their part on this. Not only was the idea of such a proxy model refuted by Hutchings, as we've just discussed, it was not even endorsed by their own experts. There is no basis in the evidence to accept that such a proxy model as proposed by Ontario would have yielded reliable data. At paragraph 502, I'm referring and reading from paragraph 81 of my reply. At paragraph 502, Ontario argues that a pre-1945 ratio expense of 31.9% is not reasonable to apply to a post-1945 world, and they gave 3 reasons. Firstly, they say that the 31.9% expense ratio is actually inconsistent with an expense ratio between 1850 and 1945, which they say goes from 0 to 4,027%. And you can actually see that on table A1 of compendium tab 13, page 85. Secondly, they say there were steady rising expenses between 1919 and 1945, and then they point to the Balmoral effect of rising government costs generally, and arguing that the Balmoral effect also applies to resources. We say none of these concerns have merit. First of all, arguing that the data shows a range of expenses between 0 and 4,027% is another example of using data improperly. The point Ontario is clearly trying to make is that, well, 31.9% is far removed from an average between 0 and 4,027%. But Ontario's proposed range comes from incorporating in data that the plaintiff said wasn't reliable. And that's the plaintiff unfriendly Irving paper data, which, as Hutchings did actually use it for calculating past amounts was not considered by him reliable enough on which to base an average cost ratio. Hutchings made had an opinion, made a judgment call, and reasonably determined, we submit, that it was appropriate to only use the data from 1898 and following. Now, when you look at the data from 1898 and following, the range is about 20 to 60% of revenues, with very few outliers beyond the two poles of 20 to 60%. Now, against a 20 to 60% range, 31.9% in my, I just found another typo. At paragraph 85 of my reply argument, I have a 39.1% ratio.
I'd already corrected it.
Okay, thank you. It's a 31.9%. So 31.9% looks very much like an accurate and reasonable average between 20 and 60, even lower than the average of about 40. So pretty conservative, pretty reasonable, pretty right on the mark, if you ask me. Now, as for the argument that there was a steady rise in expenses from 1919 to 1945, that is simply not what the evidence held. As the data shows, and that's, you can look at the expense percentages at table A1, in the 26 years from 1919 to 1945, the expense to revenue ratio increased in 15 years and decreased in 11 years. Expressed as a percentage, that's 40% of the years that Ontario points to, there was a year-over-year decrease in the ratio of expenses to revenues. Respectfully, that is not rising steadily. Another odd point is, why does Ontario focus on 1919? That's a little bit peculiar. If you actually look at the whole series of data that they transcribed from Mr. Hutchings' work papers from 1898 to 1945, you'll actually find that of those years, there's 24 years with an increase in a ratio and 23 years with a decrease. So far from showing a steady rise in expenses, the data shows variability, which makes an average appropriate, as Hutchings explained. Expense ratios were not consistently rising. They were rising and falling throughout. The use of 31.9% is a fair average to be used. Finally, Ontario relies on the so-called Balmol effect of rising government costs generally. Now, the experts disagreed with whether the effect was applicable for costs in this case. Hutchings explained that it did not apply and that Bodway and Smart provided no rationale why it would. I want to go to Hutchings' reply report at footnote 46, and it's contained at paragraph 91 of my reply argument, because Hutchings said the following in his report. Balmol explains in companion paper, the sectors that are particularly vulnerable are those where labor is the end product, like education and healthcare, rather than an input into another product. And then he quoted from an article for Balmol. Professors Bodway and Smart do not establish why the functions of collecting, regulating, and supporting direct crown revenues would be thus affected. So right out front, before anyone took the stand, Mr. Hutchings alerted the defendants to where's the explanation, explain why Balmol effect would apply. And instead of providing the court with any reasoned analysis to prove that post-1945 resource costs exponentially increased, Bodway and Smart offered an analysis of spending per capita in resource departments relative to government per capita spending overall. Mr. Hutchings explained that this comparison was not informative. He explained that there's no logical reason why each new resident of Toronto would necessitate a constant increase in Ministry of Natural Resource spending, nearly all of which he said would end up being counted against timber stumpage fees.
Can I just ask you if what you're saying is Bodway and Smart offered an analysis of spending per capita in resource departments? Is it per capita in population?
It's overall Ontario, if that's
Right.
what you mean.
Yes,
And it's per capita is per person spending. So, you know, if you're trying to extract a mineral, the amount of minerals you need as technology improves to extract minerals.
So it's per capita against resource departments.
Right.
Okay.
But the point that Mr. Hutchings was saying is that's not a meaningful explanation or a meaningful or an informative statistic, because you can have a lot more people moving to Ontario, into Toronto, and or a lot less, or any number of people moving in Toronto. But what does that tell you about the cost of extracting ore in Thunder Bay or cutting trees in Thunder Bay? It tells you nothing. Now, Ontario's argument in respect of the Balmol effect suffers from an even more critical problem than Hutchings' opinion that Balmol effect doesn't apply. It's that their own evidence doesn't support it has the effect that they claim. We say, to say that the cost of government rose generally tells us nothing about the Crown expenses related to the natural resource industries. And simply observing that the costs recorded in the public accounts shows increases over years tells us nothing if the public account data does not reliably measure expenditures of government that are causally connected to relevant resources, which is the whole point that Mr. Hutchings was making, that they were unreliable for the purpose of for which he needed them.
What he needed them for was matching.
Right. He needs them in order to identify which of those expenses are properly attributable and allocatable to the treaty territory. What we are left with in Ontario's argument about the post-1945 expenses is Professor Smart's figure 8 entitled "The Rising Cost of Government." Respectfully, Bodway and Smart's views about the Balmol effect are not supported by this chart. And you might recall, let's go to tab 14. And I don't want to portray this as an aha moment of sorts, but you know, graphs can be misleading, even if innocently so. First of all, remember that their use of per capita figures was an approach that Hutchings explains as being uninformative because resource expenses are not incurred on a per capita basis at all, like government spending on program healthcare might be. Secondly, as you can see from page 87 of the compendium, the manner in which the data presented, being on a logarithmic scale, makes it appear as though resource spending is dramatically increasing, but the data on the commentary on the chart actually suggest otherwise. And if you look at their own data, it says resource spending grew more slowly than total, 1946 to 1972. And resource spending per resident stable, 1973 to 2019. But because this is on a logarithmic scale, the bottom red line looks like it's dramatically going up after 1945. And you compare it to the blue line, which is the rising costs of government generally, it's going up from in 1920, it looks to be around what's hard on a logarithmic scale. What is that? 600, all the way up to 10,000. It's on the logarithmic scale. Even on a logarithmic scale, the rate of change is huge. But if you go over to a rescaled version of that data, it kind of shows a different picture about the rising cost of government. Yes, it shows the rising costs of government generally increasing what looks to be exponentially, but it doesn't show, and this is the same data, just presented differently. It shows expenses related to the resource ministry almost flat in comparison. Now, in seeking to explain the purpose in creating the graph at figure 8, Professor Smart and Direct at first defended his position, and then I say he contradicted himself. And what he testified to is set out at paragraph 100 of my reply argument, where he says, and yet, I'm not sure if it was in answer to a question the court asked, or or I asked, but it is, and yes, Your Honor, in that case, referring to their figure 8, we were trying to contrast the rate of growth the government is spending in the resource departments to the rest of Ontario government to say they were comparable. The bolding in my argument is for my emphasis, not they were comparable. They were growing at a similar rate. In the very next breath, if anything, resource departments were growing more slowly than the rest of Ontario. That was our point. Well, I'm not sure what the point is, because to say that they're comparable and growing at the same rate, except one is growing slower than the other, is a contradiction. Now, admitting that the resource expenses were not growing at the same rate is a fair admission, and quite frankly, it supports Stiglitz and Hutchings' view, not Bodway and Smart's. Court should remember that during cross-examination, Professor Bodway conceded that the Ball-Mall effect was only one element among many that might explain why expenses were rising after 1945. Hutchings provided that there were other explanations for rising costs generally that had nothing to do with increased expenses fairly related to relevant revenues. At the end of the day, we have Bodway's admission that Stiglitz and Hutchings' opinion about the non-applicability of Ball-Mall's effect was not necessarily wrong, just a difference of opinion. And that is the cross-examination of Bodway, page 7742, lines 10 to 15. If this is all it boils down to, given the evidence, the tenor of the evidence, and issues of credibility and reliability of experts overall, we ask the court to prefer the plaintiff's experts on this point. The next area I would like to turn to is the last areas of NCRRs, or direct NCRRs, excuse me, is spectrum and transportation. I want to start with transportation. At paragraph 108 of his opening report, Exhibit 8, Mr. Hutchings explained why transportation expenses are not properly included. In his reply report, Exhibit 10, he expanded on his reasons and took issue with the methodology of calculating expenses, the Crown's Ontario's methodology of calculating expenses, as well as the relevance of transportation expenses at paragraphs 103 to 128. In his opening report, he explained, and I'm summarizing, railways generate no Crown revenues. Railways provide transportation services and generate revenue typically in a fee-for-service manner. He explained that railways serve many other government functions, including political promises, and provide transportation services. Now, I don't recall Mr. Hutchings being cross-examined at all on his opinions regarding transportation. Recall that the evidence of trial was that the railways were not built to access resources, but would have been built in any event. Recall as well that Bodway and Smart actually, in their analysis, treat transportation as a revenue stream. And this was brought up in cross-examination where we discussed their table C.2 in their report. And they have the categories of revenues, and the last revenue stream that they have is transportation. But in the 173 years in which they study, they do not record, never mind a penny of net revenues, they don't record a penny of any revenues from transportation. All they record under the shareable revenue stream is a negative expense. Now, transportation expenses that were not incurred for the purpose of supporting irrelevant revenues should not be counted. That's, I guess, a double negative, but I'll try it again. If transportation expenses are not incurred for the purposes of supporting, regulating, or collecting irrelevant revenue, they should not be counted. That is a principle from Mr. Hutchings' analysis, and respectfully, it is one that makes sense and should be adopted by the court. I also ask the court to remind the court that Mr. Hutchings did include in the costs of both roads, he did include in his analysis of costs, both roads and railroads, where there was evidence in the record to support that those expenses on railroads and on colonization roads did in fact support a relevant expense. And on this point, on transportation expenses, his opinion should be preferred. That brings us then to spectrum. Our initial submissions on spectrum substantially, we say, refuted Canada's initial submissions in their main argument. Oddly, neither party thought it worthwhile challenging in writing the position of the other when they got to their replies. I thought that was just a coincident interest, but the court has a question.
No, thank you.
Oh, okay. Our main argument at paragraph 451 to 486, we discuss spectrum. What we'd like to do today is to highlight some of the issues regarding spectrum. We would note that Ontario did not make any representations at all on spectrum in their submissions as far as we could tell. I guess it is solely a federal stream of income. The first point to make about spectrum is that the net value of spectrum was agreed to. It's really only its relevancy that is an issue. And what we said about spectrum is the following. Stiglitz and Hutchings, this is at paragraph 457 of our main argument. Stiglitz and Hutchings opined that spectrum is a shareable revenue stream, citing the following rationales. A, spectrum is identified by Canada as a natural resource. B, the academic literature identifies spectrum as a natural resource. Like other natural resources, spectrum is actually finite in its use. D, the spectrum license is inextricably linked to the land over which the auction for spectrum rights applies. E, without access to the land, the spectrum has no value, and fundamentally this case is about the use and access to the lands and waters within the treaty territories. And finally, the federal government does not create value by their licensing. It remains the case that the value belongs to whomever has property rights in the geographic area over which the waves traverse. And G, had there been no treaty, the Anishinaabe would be the ones to control and benefit from spectrum exclusively by control of the administration control of the territory. Now, in their initial report, Professors Mintz and O'Riordan denied that spectrum was in any way related to land. They repeated that assertion at paragraph 30 of their reply report. However, the Radio Communication Act expressly refutes that argument. The Act itself states that the spectrum license is a right to use the frequency over a specific geographic territory. I'm just reading from page 463 of our main submissions.
Paragraph 463.
463, where I cite the Radio Communication Act. Now, we say that Professor Mintz and O'Riordan, they actually contradicted themselves on this very point they were trying to make when they admit, and this is a quotation I have in my argument, it is true that spectrum is a resource that earns rent according to its location. And that's in their reply report, Exhibit 30, para 27. At paragraph 28 of their main report, Professors Mintz and O'Riordan borrow an argument advanced by Bodway and Smart and argue that Canada's efficient spectrum auction process brings in far more money than other countries recover, and bringing in far more money proves that the spectrum revenues are created by the regulatory regime and not the value of the resource. I submit that that's a logically unsound proposition, because I say a regulatory regime that efficiently captures a larger portion of rents that exist does not create those rents. An example, consider the efficient regulatory regime that would permit the Crown to capture 100% of the hydro-related resource rents that exist in Ontario, as opposed to the current policy that only permits or only allows or only captures a small amount of the hydro resource rents. Now, one might congratulate the person who drafted the hydro regulations for the good work, but one would not argue that it was the regulatory regime that created the hydro rents. The rents were there all along to be captured, were being captured by other people. I mean, that's the whole meaning of resource rents. Some people capture it, sometimes it's government, sometimes it's industry, sometimes it's the consumer. But they were always there to be captured, and if you efficiently capture it, it doesn't create the resource rent. It simply collects it in a better fashion. At paragraph 470 to 475, in our argument, we discuss how Mintz and O'Riordan tried to make the argument that, well, private landowners would be unable to capture the spectrum rent. Now, the reason why private landowners don't capture the spectrum is not because they don't exist. It's because the Crown has legislatively appropriated for itself the complete value of those spectrum rights and prohibits others from jamming signals to interfere with the rights it has appropriated. This is similar to the way in which the province, save for reserves, coincidentally, which is a long story about water power on reserves, which I won't get into, but Ontario has appropriated water power unto itself, notwithstanding the riparian rights of landowners. So perhaps with that, it's been 12:30, might be a good time to break.
Thank you. And you know where you are in your argument. What's
Do I know where I am? I'll remember.
What-
Yeah, are you asking about timing?
what
Yeah.
do you say you need?
It's looking like if I don't finish today, I would be finished tomorrow morning.
So for sure you need the afternoon.
For sure, I need the afternoon. Yes.
Just giving a heads up to anyone else. All right. And so for length of break, I'm not sure how people are managing with finding food. So I'm
1:45 or 2:00. 2:00 is fine. We're not pressed for time on right now.
what's the survey say, Ms. Evans?
I think 2:00.
2:00.
I read the room well.
All right, thank you. Till 2 then.
This court is stood down until 2 p.m.